Well, thank you for congratulating me, but you should be congratulating Ugandans that have been saved of this scarecrow, which has been used over the years to achieve political ends, mischievous political ends, for your information. And also to congratulate the court upon standing firm to do the job bestowed onto them by the Constitution and the people of Uganda. As to what's happening, so far nobody has been released, and you have ably described the situation that we went to follow up because we had expected that the learned Attorney General, in writing that letter to the Chief Justice, would have put us in copy to know what exactly he was communicating. Because you see, if you are two parties and the losing party decides to start communicating with the court about a matter where my client or I have an interest as a professional, then courtesy and decency would require that you put me in copy. I ought to know. Because some of the things you are proposing to do might be illegal in my opinion, and I need to follow up. For example, when you say the DPP should liaise with the General Court Martial. First of all, the General Court Martial ceased to exist. You can only say liaise with the army, because that's where those people's files are. Number two, you cannot even ask DPP to go and liaise. DPP cannot be instructed. If you feel there is a case, actually with the decision that came up on 31st, the order says those proceedings are terminated. So there is no case. Once you terminate, there is no case. Even transfer, you must read the word transfer purposively. You cannot even transfer, because what are you transferring? Supposing the DPP looks at Nicholas Opio's case and she thinks this does not merit, I cannot proceed with it. What you do now, considering that the proceedings were illegal in the first place, you get the army leadership to liaise with the police. The police immediately starts fresh investigations, submits files carrying their findings on file to the DPP, and the DPP decides whether in the first place there is reason to charge. Two, from the time the decision was rendered, any further detention became illegal. Illegal because the court that remanded has been disbanded, and there is no saving provision in the judgment. Because unlike, I think, the Constitutional Court, I hope I'm not forgetting, had given them 2 months, the Supreme Court said with immediate effect. So you do not have any window. Now the Attorney General, in that letter, extends warrants which do not exist, actually creates new warrants by necessary interpretation. And that reminds me of those days, when I look around, apart from maybe Professor, these are the young people who were not there, when we had a Minister of Internal Affairs in this country who had detention orders pre-signed. So one day, notorious young men,
I was not there.
you were not there. No, I called you because you're a professor. I only feared you. We were there, you were not there. So the notorious young boys went and stole those letters, those detention orders, pre-signed. So they would just get Nyangweso, fill in your name and the date. The nearest police officer would arrest you and detain you without trial. Now what my brother Akili Wachonuka, Honorable, is doing is literally that. Because where does he get the powers to tell Yabashija, Commissioner of Prisons, that continue holding those people until you get further advice from me? First advice is not an order that can detain. So there is lack of decency or professional decency in that. We should have been put in copy. That's why we went up to the CJ's chambers to follow up and see if actually that letter is there. We confirmed it is there, but we were not given a copy, I must say. Well, you cannot fault the CJ's chambers, because if the owner of the letter did not choose to copy you in, I'm only cautioning KK that that one is professional misconduct. You must put me in copy. So currently, yes, all those people continue to languish in detention illegally, and we are taking some steps, as you must have seen, at least in the case of Dr. Besigye and Haji Obeid. We're also taking steps in respect of Council Aaron Kiza. We're also taking steps in respect of our NUP supporters. For the relatives of those people who might be affected beyond that, those groups I've mentioned, they may feel free to approach us so that we could pursue also their remedies. Otherwise, they are there illegally.
Honorable, before I get to Professor Mbazira, why is it complex to implement this judgment? Why is it becoming, because you asked a question on the floor of Parliament about timelines. Why is it becoming a very complex matter to implement this judgment?
Well, it is complex, first of all, because of lack of goodwill. It's bad faith, purely bad faith. Because immediately after the judgment, you remember the tweet by one Chris Magezi?
Yes.
And Magezi means what? Magezi means intelligence, right? Wisdom. One Chris Magezi purporting to speak for the UPDF, because he said official statement of the UPDF. His first knee-jerk reaction was Besigye will not be released until and unless we receive instructions from Yoweri Kaguta Museveni, the commander-in-chief. I remember, and then the Sun immediately, the following day, came out with another tweet and said, I'm back on Twitter, on X, and then he said, Besigye will only live in two ways. The first will be in a coffin when we have fired him bullets, shot him with bullets. The second, on his knees, upon apologizing to Mzee, that apologizing to his father. Only those. So that explains the difficulty with which implementation may be met.
Professor, coming to you,